Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Gang Crimes Lawyer, Chicago, Illinois. Being charged with a gang-related crime in Chicago, Illinois can have immediate and life-altering consequences. Illinois prosecutors take gang allegations extremely seriously, often pursuing enhanced felony penalties that can lead to significant prison time and six-figure fines. If you're facing gang crime charges in Chicago, you need an experienced criminal defense attorney who understands how these cases are investigated and prosecuted. At Combs Waterkotte, our Illinois gang crimes lawyers have decades of combined experience defending clients against serious felony charges throughout Chicago. We understand the complexities of Illinois gang laws and will work to build a strong, strategic defense tailored to your case. Call 3125-00-HELP today to start protecting your rights, your freedom, and your future. Gang Crimes Lawyer in Chicago, Illinois. Serving all of Cook County. Gang crime charges in Chicago and throughout Cook County are aggressively prosecuted, often carrying enhanced penalties that can significantly increase the stakes of your case. Whether the allegations stem from mistaken identity, circumstantial evidence, or overreach by law enforcement, you shouldn't face these serious accusations alone. You need a criminal defense team that understands how to challenge gang-related activity crimes and protect your rights at every stage of the case. At Combs Waterkotte, we bring over 8 decades of combined experience defending clients against gang crime charges across Cook County. We take a personalized, strategic approach, carefully examining the prosecution's evidence, questioning alleged affiliations, and identifying weaknesses in their case. From negotiating for reduced charges to defending you aggressively at trial, we're prepared to fight for the best possible outcome. If you're ready to protect your future and take control of your defense, contact Combs Waterkotte online or call 3125-00-HELP today. The sooner you have an experienced legal team on your side, the stronger your defense can be. How does Chicago, Illinois law define gang? In order to understand gang crimes and their charges in Chicago and Cook County, first, it's important to understand how Illinois law defines a gang in the first place. The latest definition was codified in 1992 in the Illinois Street Gang Terrorism Omnibus Prevention Act, 740-ILCS-147/, which defines a street gang or gang as a group or network of 3 or more people with an established hierarchy that engages in a pattern of criminal activity, with a common name, flag, or insignia, a common creed or belief, a leadership or command structure, a claim to a specific area or territory. The Act also goes on to define other terms related to gang crimes, including gang member, a person who belongs to a gang and knowingly acts or associates with a pattern of gang-related criminal activity. Gang-related activity. Any criminal activity authorized by a gang leader or their representative with the purpose of increasing the gang's size, grow the gang's activity in illegal criminal markets, getting revenge on another gang member, intimidating a witness to the gang's activities, making money for the gang. These definitions are woven throughout Illinois' gang-related criminal charges. The charge a Cook County court may levy against a gang member depends on what action that gang member took and the severity of the act in question. Common gang crimes in Chicago, Illinois. There are numerous gang-related crimes on the books under Illinois law for which Chicago gang members can be arrested or charged. Some are gang-specific laws, while others are general criminal acts that have gang enhancements written into them. Gang members in Chicago or Cook County may be charged with the following offenses if they commit them on behalf of their gang or as part of gang-related activities. Unlawful participation in street gang-related activity. Street gang criminal drug conspiracy. Street gang recruitment on school grounds. Unlawful possession of a firearm by a street gang member. Armed violence. Aggravated intimidation. Aggravated identity theft. Obstructing justice. Dogfighting. The prison sentences and penalties Cook County gang members may face for these crimes range from minor offenses to mandatory minimum periods of decades in prison. The sentence comes down to what crime was committed, where it was committed, and the severity of the offense. What are the penalties for gang crimes in Chicago, Illinois? With very limited exceptions, street gang crimes in Chicago, Illinois are nearly always charged as felonies. The charges span the Illinois Criminal Code's felony spectrum, with relatively low-level felonies all the way to Class X felonies. Class X felony gang crimes in Chicago, Illinois. A Class X felony offense is the most serious felony under Illinois law. Penalties range anywhere from 6 to 60 years, and some gang-related Class X felonies come with harsh mandatory sentences. Class X gang crime felonies in Chicago, Illinois include street gang criminal drug conspiracy, 720 ILCS 570/405.2, 15 to 60-year mandatory sentence for large amounts of heroin, fentanyl, cocaine, morphine, or peyote. 10 to 30-year mandatory sentence for medium amounts of heroin, fentanyl, cocaine, morphine, or peyote, and violation of the Methamphetamine Control and Community Protection Act. Also comes with a fine up to $500,000. Armed violence, 720 ILCS 5/33A-1. 20-year minimum sentence for firing a gun while committing a separate felony in a school. 15-year minimum sentence for using a Category 1 weapon, handgun, sawed-off shotgun, or sawed-off rifle, in the commission of a separate felony. Aggravated identity theft, 720 ILCS 5/16-30. When the value of the theft is $100,000 or more, for any subsequent offenses, regardless of the value stolen in either offense. Class 1 felony gang crimes in Chicago, Illinois. Class 1 felonies come with the next most severe criminal penalties under Illinois law. Plenty of gang-related crimes in Chicago or Cook County can result in a Class 1 felony charge and 4 to 30 years in prison, including aggravated intimidation, 720 ILCS 5/12-6.2. Threatening someone not to do something, like enter a territory or testify in court, with the use of force or threat of force on behalf of one's gang. Street gang recruitment on school grounds, 720 ILCS 5/12-6.4. Knowingly using force to coerce or recruit someone to join or stay in a gang. Threatening physical force to coerce or recruit a minor to join or stay in a gang, whether in person or through text or social media. Aggravated identity theft, 720 ILCS 5/16-30. When the value of the theft is between $10,000 and $100,000. Class 2 felony gang crimes in Chicago, Illinois. A Class 2 felony gang crime conviction in Chicago can result in a prison sentence between 3 and 14 years. Some of the most common Class II gang-related felonies we see charged in the Cook County, Illinois area include unlawful possession of a firearm by a street gang member, 720 ILCS 5/24-1.8. When a gang member knowingly possesses or conceals a gun outside of their home or business without a firearm owner's identification, FOID card, that is, on a road, alley, sidewalk, etc., possesses an easily accessible firearm and ammunition in their vehicle without a valid FOID card outside of their property or garage, i.e., on a street, highway, alley, etc. No eligibility for probation if the firearm was loaded. Aggravated identity theft, 720 ILCS 5/16-30. When the value of the theft is between $300 and $10,000. Class III felony gang crimes in Chicago, Illinois. The lowest-level felony gang crime offenses, Class III felonies, can result in 2 to 10 years in prison if a gang member is convicted. Common offenses for which Chicago gang members are charged include obstructing justice, 720 ILCS 5/31-4. Destroying evidence, planting false evidence, threatens witnesses, or flees Illinois to avoid testifying in a criminal case. Dogfighting, 720 ILCS 5/48-1. Owning or trying to sell a dog bred for fighting in relation to gang activities also results in a $50,000 fine. Misdemeanor gang crimes in Chicago, Illinois. There are some relatively low-level Chicago, Illinois gang crimes that result in a misdemeanor charge instead of a felony. The most common one we see at Combs Waterkotte is unlawful participation in street gang-related activity, 720 ILCS 5/25-5. Charged when someone is let out on probation or parole and has been told by the court to stay away from known gang members but does not comply. Charged as a Class A misdemeanor, up to 364 days in jail. Criminal defense strategies against Chicago gang crime charges. Chicago gang cases are complicated. They involve complex networks of people and criminal activity in which prosecutors must prove the defendant's involvement in and association with those people and activities. That's why if you're charged with a gang-related crime in Chicago or Cook County, you need a criminal defense attorney who knows how to navigate these complicated, confusing charges. Combs Waterkotte can help. We've found the following criminal defense strategies to be particularly effective when defending Chicago residents charged with gang crimes. Challenging gang affiliation and lack of intent. One of the most effective defenses in Chicago gang cases is disputing whether the defendant's actions were actually gang-related. Illinois law requires proof that conduct was done to benefit or further a street gang, not just that the defendant knew gang members. Attorneys often argue lack of intent, showing the accused was merely present or associated socially, without participating in or promoting criminal activity tied to a gang. Fourth and Fifth Amendment violations. Gang investigations in Chicago frequently rely on aggressive policing tactics, including surveillance, traffic stops, and custodial interrogations. Defense attorneys can challenge whether evidence was obtained lawfully under the Fourth Amendment, seeking to suppress illegal searches or seizures. Similarly, statements may be excluded if Miranda rights were violated or if confessions were coerced, significantly weakening the prosecution's case against the defendant. Duress, coercion, and entrapment defenses. In some cases, individuals accused of gang crimes in Chicago acted under pressure or manipulation rather than free will. A duress or coercion defense argues the defendant faced immediate threats of harm if they refused to participate. Entrapment may apply when law enforcement improperly induces criminal conduct. These defenses are especially relevant in Chicago gang contexts, where fear, intimidation, and undercover operations often play a central role. Alibi and misidentification defenses. Gang cases in Chicago often rely on eyewitness testimony or circumstantial evidence tying a defendant to a group. An alibi defense can be powerful, demonstrating the accused was elsewhere when the alleged crime occurred. Attorneys may also challenge misidentification, especially where police rely on unreliable witnesses or social media images. Establishing reasonable doubt about identity can dismantle the prosecution's theory of gang involvement. Self-defense and defense of others. Violent charges tied to alleged gang activity may still be justified under Illinois self-defense laws. If a defendant reasonably believed they faced imminent harm, they may be legally justified in using force. Similarly, defense of others applies when intervening to protect another person. These arguments focus on the circumstances of the incident rather than gang affiliation, reframing the case around lawful, justified conduct. Lack of evidence and burden of proof. Prosecutors must prove beyond a reasonable doubt that both the crime occurred and that it was gang-related. Defense attorneys often focus on gaps in evidence, such as weak connections between the defendant and alleged gang activity. Simply knowing gang members or being present in a certain neighborhood is not enough. Highlighting these weaknesses can lead to reduced charges or even a complete dismissal. Challenging social media and digital evidence. Chicago gang prosecutions increasingly rely on social media posts, text messages, and videos to establish gang affiliation and intent. Defense strategies often involve questioning the authenticity, context, or ownership of digital evidence. Posts may be exaggerated, taken out of context, or created by someone else. By undermining this evidence, attorneys can weaken claims that the defendant acted to benefit or promote a gang. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.